if you want to take the whole thing out of the court process, use that revocable living trust in order to transfer title the right way, based on fact and established law, not based on some legal theory that has actually been disproven. Hi, Jeff Mersace, the Plain English Attorney, and welcome to the video. Today we're going to go over something called, let me see if I can pronounce this correct. It's been a long time since I took French. Cestui Que Vie Trust. Now, what exactly is this type of trust? The theory behind it, and it is a legal theory, somebody has passed on and you're the heir, you should be able to simply make a claim against the government to get the beneficial ownership, if not the titled ownership, because the state is holding it in trust. Okay, definitely sounds strange, and it is, but look, this is a legal theory, and I have had several people say, yes, you should really discuss this and talk about this type of trust. It's something that's out there. And I've even had somebody say, can you help me get this type of trust from my parents because they've passed on? All right, what exactly is it? Basically, the legal theory comes under an act from 1666 that came over with English common law, and it was related to someone was presumed to have passed on. The state had their property, but then they showed up and said, look, I'm alive. You need to pay me this property. And it's all based upon a whole bunch of different legal theories. And honestly, they don't connect. They don't make sense. It's kind of like when the same exact person says that Joe Biden is president and he's screwing up the whole country, but at the same time that, no, Trump is actually president and he's running the shadow government, so he's who's really in charge, but none of the things that are screwed up are his fault. It doesn't connect logically, rationally, or legally. So this particular type of trust, there was a case, and we'll find a way to get a link to it somehow, to put into the video and into the description. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. Where someone was making a claim saying, hey, my mom passed on, and therefore with my mom passing on, she executed this statement that said that I am to be the permanent and irrevocable power of attorney over this particular trust. Well, how did this supposed trust, come into being? Well, according to the filing in this case, back in 1933, the United States government actually went bankrupt, and therefore they confiscated all of the gold to help with this bankruptcy. And now there actually is no money in the United States. It's not actual money. Okay? So there's no actual money, and therefore the people of the United States are actually kind of these bankruptcy creditors, I guess. And so when someone passes on, and there's assets that are titled in their name, it's technically the United States government that is holding this in trust. Or it could be the state government, depends on who you're talking to with this theory. It's the state government that is holding this property in trust for their benefit, and they just simply need to make a claim in order to get the ownership. And therefore, you don't have to deal with probate. You don't have to deal with filling out any of those forms, because this act that was English common law that came over from 1666 somehow or another supersedes all of the other subsequent laws regarding setting up a state administration and trusts and all the, the uniform trust codes, all that. None of that stuff matters. And it doesn't even matter about the debtor and creditor laws that have changed in the centuries since 1666. No, this is what holds. Okay, it doesn't make sense. Now, here is exactly why, because this is out there enough that we really should take a few minutes and go through exactly why it is. So let's look at that. There's that underlying act of 1666. The person who's coming and making the claim isn't the person who owned the property in the first place, was declared legally dead, and then showed up. That was the entire purpose behind that law, was so that they could get their property back from the government, because if they weren't actually dead, the government was technically holding it in trust under the terms of this act so that they could get their property back from the government when they weren't actually dead. So they had to show that, yes, I am alive and here's who I am, and okay, great. The courts are authorized to give you the money. That's not what's happening here. They're trying to avoid probate, but not actually set up a revocable living trust in order to put the assets into the trust and maintain them over in an actual trust, which will then pass to whomever the beneficiary is in the next generation. If you don't do that, if there are assets that remain titled in a deceased person's name, well, that's when probate takes over, because that's, again, these acts, the probate acts and setting up a state administration in all the different states, are completely separate from common law, and it supersedes it because, again, we adopted the common law from England, and here's the way it worked. When we broke away as a country, 1776, and then started setting up laws and rules, and eventually the Constitution, we said, all right, we're keeping all of the English common law except what we change. And all of the different states, they're also accepting English common law and what they adopted as colonies, unless it ends up being changed. Well, all of these estate administration setups throughout the 50 states, they were set up subsequent and therefore override that 1666 act. Now, let's talk about actual trusts and actually avoiding probate. It's not as simple as simply writing out some kind of declaration and filing a couple of pieces of paper. That's basically a way of trying to avoid probate that's completely based on wishes and desires and trying to mentally manifest something that isn't actually in the law. Now, look, if you want to simply go ahead and take whatever the state setup is, go ahead and die without a will. If you want to say, here's where my property goes, but still keep probate, go ahead and do a will. Because that's exactly what happens with the last will and testament. A last will and testament is nothing more than a writing saying, okay, at the end of this probate process, here's my will, here's where I want stuff to go, and here's the person I want to be the executor, and maybe there are a couple of other clauses and provisions in that, but basically we're saying, let's take the state probate court process. That's fine with me. I have a last will and testament. And that probate court can eventually clear title over to the to the named beneficiaries in the will. So yeah, a will means probate. If anybody tells you a will means I'm avoiding probate, no, that's not true at all. That's just as true as this weird Cestui Que Vie Trust just magically somehow or another avoiding probate or any other kind of court administration because of some common law act that's not even on point. All right. If you do want to avoid probate, that's where we have the revocable living trust, and the reason and the theory behind all of this, which is in established law, which is subsequent to this 1666 act, and is in full effect in various shades in all 50 states. It's avoiding probate because it's based on title. So you're actually taking title ownership and putting it into the trust. So anything that's inside that revocable living trust, or there are state sanctions, state law that allows certain things to have beneficiary designations. They can pay into this revocable trust immediately upon death. All right, you can have that. It ends up in the trust, and then the trust can sign over the title paperwork. So this is actually taking this out of that state government probate court process, and it's already in the law. So this is something that I do talk about a little bit in my book, The Divorce Firewall Strategy, that look, if when it comes to divorce, you can simply go ahead and say, well, okay, we're going to get married. We're not going to do a prenup. We're just going to accept what the state says. When it comes to estate planning, if you're just going to go ahead and do a will and have the court process okay, or if you don't want to do a will, hey, well, look, the state has a plan for you. If you want to take the whole thing out of the court process, use that revocable living trust in order to transfer title the right way, based on fact and established law, not based on some legal theory that has actually been disproven. So where did all of this stuff kind of come from? Look, it's all of this sovereign citizen stuff that's just some twisted, circuitous, weird, and unconnected logically theories that, well, I want something a certain way, and therefore that's what it is, and it doesn't have a basis in reality. All right, so that's probably a little bit shorter video than we're used to having, but I thought hopefully at least you'll find it entertaining, if not necessarily informative. But if you come across somebody saying, oh, you should just do a Cestui Que Vie Trust, that's not actually setting up a trust. That's just trying to write a couple of pieces of paperwork after someone dies and expecting the government to just pay you a bunch of money. Doesn't work. So please, as I always tell my clients, stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.